We're joined now with the claim to trial attorney, Michael Carter. Michael, the Supreme Court just issued a unanimous decision ruling that Colorado and other states cannot keep Trump off the ballot. What was significant about this ruling and potentially noteworthy going forward?
The concurring opinion of Sotomayor, Kagan, and Jackson. They point out, and to answer your question succinctly, there's a divide on this court, and the stakes are getting higher, and I expect it to be gloves off in the not so distant future. These justices at first proclaimed the standard of reviewing courts that it is not necessary to decide more to dispose of a case than it is necessary, or if it is not necessary to decide more to dispose of a case, then it's not necessary to decide more. And what did they cite to? They cited to the Dobbs decision from 2022 overruling Roe v. Wade. And they talk about the principle of judicial restraint. Now, people that have heard me speak know I speak about the Federalist Society a lot and its effect on justices in our judicial system. And the president of the Federalist Society has said there's going to be a lot less judicial restraint and a lot more interpretation. And that's exactly what 5 justices did on this case. They didn't need to go any farther than to hold Colorado couldn't do what it did. But they did. They went farther and they explained what should happen and how Congress should act, and basically put hurdles up to keep an insurrectionist from running for political office. And the concurring opinion actually goes on to basically write about a particular insurrectionist. Now, they don't name Trump, but they all but name Trump and explain that this court is going out of their way to insulate that insurrectionist from other mechanisms that could keep him from running for office.
So what you're saying is that despite it being a majority opinion, despite 9 justices ruling the same way, a few justices in concurring opinions basically are saying that the majority opinion justices, the conservative justices, have gone a step further than the actual opinion and kind of judicially overreached in trying to insulate the former president.
Right. And they do so, as is pretty typical, I would call it the Anthony Scalia way. They cite to history, but they don't cite it correctly. They cite, it's an ends justifies the means sort of a mentality. So they cite to a case called Griffin. And the concurring opinion points out that Griffin is a non-precedential lower court opinion. It's not binding. It's not even authority. It's authority for no court. It's a holding by one judge. And then the majority goes on to cite Senator Trumbull's statements way back when for enforcing that Section 3 provides no means for enforcing itself. However, as the concurring justices point out, that particular senator also said the 14th Amendment that if the 14th Amendment itself prevents a person from holding office. So what the majority did is they looked back in constitutional history and they found a senator that said something, a part of a sentence that they liked. They cited to that part of the sentence, and then they ignored the more important part that is directly contrary to what it is the majority wants to hold. And I mean, that is Justice Scalia reasoning in a nutshell. You pick out little things here and there that can go your way, and you ignore the gestalt, or you ignore the clear language, in this case, that follows afterwards.
So the concurring opinions then go out of their way to say basically that the majority is essentially engaging in judicial activism, which you always hear conservatives claim the Democrats are doing, but basically using whatever reasoning they can to justify their ruling. And they're basically saying that they've gone out of their way to not just issue this ruling, but go a step further and protect the former president. Do you think that this majority opinion then, do you think that the conservatives on this court, given what you just saw in this ruling, are going to try and insulate the president and give him another assist, so to say, in the upcoming case that will decide his presidential immunity? Does this give us any indication as to what's going to happen there?
To answer the last question in that, I don't know. I don't know. I still believe in the legal system, and I believe that every case will be decided on its own merits. This case, I don't think reasonable people can disagree about the general holding. It makes sense in our federalist system. But to go beyond that is a problem. And I don't know if you call it judicial activism or something else. When a court, you have to believe intentionally and knowingly, picks a piece out of a statement, but doesn't give the whole statement in context.
What do you think that means when they don't give the whole statement in context then?
I'll leave that for each person to decide on their own. I certainly have my view. My view is I'm very, very skeptical about whether the majority had good intentions here. They're a reviewing court, and they're supposed to exercise judicial restraint. They didn't. They went beyond that, and the concurring justices point out what they did effectively insulates all alleged insurrectionists from future challenges to their holding federal office. Now, that is not a meek statement. That is not a mild statement or a reserved statement. What they're basically saying is the majority opinion, insofar as it raises the bar or interprets for the first time what would be required for a Section 3 removal, they have done so in a way that protects insurrectionists and allows insurrectionists to continue to seek and hold federal office. And that's the concurring justices. That's what they wrote.
That's terrifying. I mean, I guess all we can hope is that the justices who went above and beyond to try and insulate the former president here don't, in his coming Supreme Court cases, try and protect him further and do something crazy like grant him full presidential immunity. I know a lot of lawyers believes that they may provide some clarity on the issue of presidential immunity, you know, maybe some type of immunity with some acts while president. I know Jack Smith actually, you know, he wants some clarification by the Supreme Court. Yeah. How do you think the Supreme Court's going to rule? Just your opinion on his immunity claim.
It wouldn't surprise me if Alito and Thomas side with the former president, regardless of the issue. I think their votes are pretty much guaranteed. I think that the concurring justices today will give it a scholarly and reasoned analysis. And I'm hopeful that Kavanaugh, Barrett, and Gorsuch do so. I think the outcome is pretty clear in this particular set of facts that someone who's not president can't claim presidential immunity for something they've done while they're not president, and that someone who is president cannot claim presidential immunity for an act that is a criminal act. I think that's pretty clear. And I hope I have some basis to keep that belief after the court renders its opinion.
Yeah, I think we're all holding out some hope that there's some semblance of fairness and adherence to the law with this upcoming decision. But after what we've seen, I'm not holding my breath.
If this court stands presidential immunity on its head and finds that numerous tribunals have determined it incited an insurrection and knowingly did so, If the Supreme Court finds immunity for that, then the Roberts Court will go down in infamy. I mean, they will be held to be one of the lowest in terms of respect, dignity, adherence to the law, fundamental justice in history. So
Yeah.
there's a lot riding on this.
Yeah, I mean, they'll also be giving Trump carte blanche to do whatever he wants, which is a scary thought. Michael Carter, thank you so much for joining us. Michael's going to continue joining us to break down all the latest in Trump's legal woes as they develop through the election. With Really American Media, I'm Justin Horwitz. Thanks again for joining us, Michael.
Thank you.